I'm Josh Escobedo with Weintraub Tobin.
And I'm Scott Hervey with Weintraub Tobin. The Copyright Office recently rejected an application to register AI created artwork. We're going to talk about the implications of this on this installment of the briefing by the IP Law Blog. On November 3rd, 2018, Stephen Thaler filed an application to register a copyright claim in an image entitled A Recent Entrance to Paradise. This image is part of a series which Thaler describes as a simulated near-death experience in which an algorithm processes pictures to create these hallucinatory images and a fictional narrative about the afterlife. The author of the work on the application was identified as the Creativity Machine, with Thaler listed as the copyright claimant alongside a transfer statement, ownership of the machine, meaning he owned the machine. In his application, Thaler left a note for the office stating that the work was autonomously created by a computer algorithm running on a machine with minimal human intervention, and he was seeking to register this computer-generated work as a work for hire as the owner of the Creativity Machine. In an August 12, 2019 letter, the Copyright Office registration specialist refused to register his claim, finding that it lacks the human authorship necessary to support a copyright claim. Thaler requested reconsideration of the denial. Thaler argued that the human authorship requirement is unconstitutional and unsupported by case law, and that the office should register copyrights in machine-generated works because doing so would further the underlying goals of the copyright law, including the constitutional rationale for copyright protection, that there's no binding authority that prohibits copyrights for computer-generated works, that copyright law already allows non-human entities to be authors under the work made for hire doctrine, and ultimately that the Copyright Office is currently relying on non-binding judicial opinions from the, quote, Gilded Age to answer the question of whether computer-generated works can be protected.
And this isn't the first time that we've seen human authorship requirements imposed as a decisive factor in copyright cases.
That's right, Josh. This particular case, or the particular case that you're talking about, was literally a bunch of monkey business.
Literally, that case involved what became known as a monkey selfie. Photographer David Slater was visiting a national park in Indonesia when a black monkey grabbed his camera and took an array of self-portraits. These amazing photographs ran in a July 5 article about the incident that was featured in the UK's Daily Mail. 2 of the 4 photographs were featured in the article and included copyright notices indicating Cater's news agency, which was Slater's photo agency, was the owner. Slater subsequently tried to get the photo removed from one of his most famous photos from Wikimedia, a royalty-free photo collection website. That wasn't what went to trial, though. In an interesting twist, PETA sued Slater and others for copyright infringement on behalf of the monkey. The Northern District of California and the Ninth Circuit found that the Copyright Act did not provide statutory standing to the animals.
According to the Internal Copyright Office practices, as codified in Rule 503.03, in order to be entitled to copyright registration, a work must be the product of human authorship. Works produced by mechanical processes or random selection without any contribution by a human author are not registrable. Thaler was challenging the legitimacy and constitutionality of this practice. So Thaler had to prove to the Copyright Office that either these works were the product of human authorship or convince the office to depart from a century of copyright jurisprudence.
And apparently the Copyright Office was unconvinced.
That's right. The Copyright Office quoted the holdings of numerous cases for the proposition that copyright protection was limited to the creation of human authors. The Copyright Office quoted 2 Supreme Court cases and the holding of lower courts, including the Ninth Circuit and the Seventh Circuit case of Kelly versus Chicago Park District, which rejected a copyright claim of a, quote, living garden, close quote, because authorship is an entirely human endeavor, and a garden owes most of its form and appearance to natural forces. Another Ninth Circuit Circuit case involved the depiction of jellyfish. And the court found that depictions of jellyfish are not protected by copyright because material first expressed by nature are the common heritage of humankind, and no artist may use copyright law to prevent others from depicting them. In its final rejection of Thaler's reconsideration request, the office noted that although it is not aware of a United States court that has considered whether artificial intelligence can be the author for copyright purposes, courts have been consistent in finding that non-human expression is ineligible for copyright protection.
So what do you think about that, Scott? Do you think artificial intelligence should be able to be considered the author for purposes of the Copyright Act?
That's a real interesting question, Josh. So, I mean, Thaler really has been involved in trying to push for intellectual property protection for AI created works. Now, you kind of have to wonder, does this really matter all that much? Is this form over substance, right? Because, you know, this rejection doesn't mean that all art created with an AI component is ineligible for copyright protection. Thaler in his copyright application emphasized that humans weren't meaningfully involved, because his goal was to prove that machine-created works could receive protection. But if Thaler had filed an application and had stated that the work was a product of their own creativity that was executed by the machine, the outcome probably could look different. He probably would have achieved a copyright registration. But Thaler's entire point here is to establish that AI can achieve copyright registration. And he's also tried to pursue patent applications on behalf of AI created inventions.
That's interesting. I suppose as a practical matter, I wonder what's the point of the AI actually being deemed the author of the work? What are your thoughts on that, Scott?
One would have to ask Thaler, right? I think because he's the one advancing this proposition that that artificial intelligence can create and can invent, and that creation and invention are not limited to human minds. When you think about that, that's pretty revolutionary. And it's pretty, I don't know, maybe some might say frightening to think that machines can take maybe not take the place, but can invent and create as can a human mind. And we're not talking about, we're talking about pictures and invention of things, but also songs and other forms of creative expression. I know it's an interesting proposition. I know that we're not going to hear the last of Thaler, and as AI becomes more prevalent in our day-to-day, living, we might see some bigger organizations that have a bigger stake in AI try to push these bounds as well. I'm thinking, Amazon and Google in particular.
Sure, I'm with you there. I don't think we've heard the last of this sort of situation, Scott. Thanks for bringing this to our attention.
Thanks, Josh.
I hope you enjoyed this installment of the briefing by the IP Law Blog. Don't forget to subscribe to our podcast and YouTube channel. For additional content, visit our website at theiplawblog.com. Thanks.